Thank you both very much. All right.
Next case on the docket is HB and Company versus Florida Power Corp.
May it please the court, my name is Keith Hope of the Hope Law Firm in Gulfport, Florida, and I'm appearing on behalf of the appellant, HB Watson Services, Inc. Unless the court has questions for me on the first two issues, statutes of limitations or frauds, I would like to direct my argument to issue number 3 because I don't think the court will have any problem with those first two issues. However, I would be happy to answer any question you have about them. If not, I'd like to go right to issue 3, which is, and it's a tipsy coachman issue because it wasn't ruled on below, but the issue is whether on summary judgment an oral contract.
To be honest with you, I'm having a lot of trouble with the statute of limitations issue here. I mean, it seems to me like and I haven't prejudged the case or anything, but it just seems to me that may be a valid basis for the trial court's ruling here. Just tell me where I'm wrong on that. So. Well,
the whole legal argument the appellee presented to the trial court and here has to do with causes of action for quantum merit. And it makes perfect sense, and the law states, in fact the cases they rely on, is that if your suit is not for breach of contract but for quantum merit, then your statute starts running when you've finished your services. That's absolutely clear. But this
so
is
the
not,
language of those cases don't limit it to quantum merit, correct? They just happen to be brought in a quantum merit context.
I would agree that there are language in those cases, broad language, but that language is in stark contradiction to the ruling law. The law is clear in Florida. There is no dispute. Even this court's case in CORP versus City of West Melbourne. If it's a breach of contract case, the statute cannot begin to start ticking until there has been a breach. This court...
You're saying that the breach occurred when you submitted the bills and they didn't pay it, but the bills weren't submitted until long after the services were completed. This contract doesn't even have if it's a contract at all. I mean, I have problems with this being a contract for services and an expectation of payment. But in any event, let's just assume it's a contract. If this was a contract, there was no ending date, and the case law says if there's no ending date, the law presumes there's a reasonable date. There's a reasonable standard, right? Doesn't the law assume that if there's no, ending date and the services are completed, that the contract expires or ends within a reasonable time after that? There's no...
I'm not aware of that at all, and that's going to the issue of term, whether there was an agreed-upon term in this contract.
Right, that's what I'm getting at. I mean, what is the term? There's no ending date for the term of the contract expressed in this alleged oral contract. So the law would presume that it's reasonable, right? A reasonable time limit.
Well, first of all...
Is that not true? Or?
Well, I think you're right. The law will, if a contract does not say it's for X months or X years, the law implies a reasonable term.
Right.
They made that argument in the trial court. They abandoned that argument here. In their brief, they only argue that the contract was not definite as to price. They abandoned the issue of term. So that's not...
Well, they didn't abandon the statute of limitations.
Correct.
And so we have to determine when did the contract... go ahead.
I'm not sure that's... Here's my point. There is no distinction in the law as to whether it's a contract for the sale of goods, the contract for services, the contract for anything. It doesn't matter.
Is there even an issue of fact as to when these services ended?
No, there's not. As a matter of fact, the parties agreed below and in their briefs, and the trial judge put a finding of fact into his final summary judgment that the services were completed on or before the date of the signing of the contract in January of 2004. That's not an issue. Everyone knows when they did end.
And then you submitted your bill for services, what, a year later or some period of time later, right?
Correct.
And there's no question that if we calculate that is the ending date of the contract, when the trial court found that the contract ended, that the statute of limitation period would have expired.
The trial court did not find that that's when the contract ended, Judge Sawai. The trial court found
that's when the
services were completed. But that doesn't mean the contract's ended. The contract's not ended till it's performed by both parties, and the performance by Progress Energy would be paying.
So could your party have waited 20 years to send an invoice and not have a statute of limitations problem?
That is, I would have to say, based on the law, you cannot file a lawsuit.
You would have to say what? Yes or no? Yes or no?
I don't know. I mean, that makes it a harder case when you use 20 years.
That's the ultimate issue here, isn't it? I mean, it's your position that until you send the invoice, the cause of action hasn't accrued. Isn't that your position?
No, sir. My position is the cause of action has not accrued for a contract action until there's been a breach. And there can't be a breach.
It can't be a breach until we send you an invoice and you don't pay it.
There can't be you can't file a lawsuit if you don't allege there's been a breach. And so if there hasn't been a breach 2 months after his services were completed, he couldn't file the suit. You have to allege in a complaint for breach of contract.
So if you didn't send an invoice for 20 years, and therefore the other side didn't tell you they weren't going to pay you, then the answer to my question would be yes, you could file it 20 years later, or 40 years later, or 50 years later, right?
I suppose yes.
So if you were to win this appeal, and we were to write an opinion that would establish a principle of law to be applied across the board, you would want to see an opinion that would allow somebody to wait 20 years to send an invoice and then be able to bring a cause of action.
No, Your Honor, I don't believe you will be announcing a proposition of law. The proposition of law has already been established by the Florida Supreme Court. In any contract action, the statute does not start until there has been a breach.
Getting back to Judge Palmer's question, isn't that why the law would say that, well, it's the term of the contract is what we consider to be a reasonable term, and then when the services, he rendered the services, the contract expired at that time, and therefore you had a certain amount of time after that to file your lawsuit for...
No, Your Honor, that would be exactly correct if the cause of action here were for quantum merit. If you don't have a contract and you sue for quantum merit, your clock ticks on the day you finish mowing the yard.
I don't read those cases as being specifically limited to quantum merit. I really don't. But in any event, I mean, there's nothing in those cases that say that this rule specifically applies to quantum merit and is specifically limited to that. I haven't read those cases to say that.
Well, if they don't say that, they're in contradiction to the precedent of the Florida Supreme Court, the 4th, the 3rd, the 2nd, and the 1st.
Let me ask this question. What about course of dealing? Your course of dealing indicated that there was a 30 or 60-day period for the submission of the bills in your course of dealing with the other party, and then it was net 30 days for payment. And that was your course of dealing throughout your dealings in just about every type of contract, from what I read in the notes here. So wouldn't the course of dealing establish, when you were supposed to submit your bills and when the bills were supposed to be paid?
The 20 years preceding this job, there was a course of dealing. But there was never a term in those oral contracts as to when you had to submit your invoice or when it had to be paid. That was never a term. They called him. They said, we want you to do job X. We don't care what the price is.
Wasn't the course of dealing and after the services were completed that the bill would be submitted within 30 or 60 days and after that would be, payment must be made net 30 days after that? that was not your course of dealing?
No, because there was nothing in the contracts. Those were all oral contracts.
Well, this is an oral contract.
Never a
too.
specific
This is an oral contract.
I know, Judge, but I'm trying to tell you about the course of dealing contracts.
Okay.
There was never an agreement that you must submit an invoice within 30 to 60 days, and we must pay it within 30 days after that. That wasn't in the agreement.
But that's what you did in the past on all your dealings with the opposite party, oral contracts for services. It was the bill would be rendered 30 to 60 days after services were complete, and then after that it was net 30 days for payment. And so you're asking us to, well, that was a course of dealing and everything else, but this is an exception.
The course of dealing issue goes to contract complied in fact. That is where this court, if you were analyzing the issues, that's where you would analyze the course of dealing. But whether an oral contract existed has nothing to do with the course of dealings. It has to do, was there an agreement as to what he was to do, and was he going to get paid?
Oh, no, I'm talking about, let's assume there was an oral contract. You're saying that there was no expiration date, and that the contract didn't expire or it wasn't completed until you submitted your bill and they refused the payment. But I'm saying that the course of dealing seems to indicate that the contract expired, the oral contract expired when the services were complete, because it seems to me your course of dealing in all these other prior contracts was once the services were complete, 30 to 60 days you submitted your bill and they had 30 days to pay. So that would establish that after the services were complete, in this particular case, your course of dealing would be 30 to 60 days after the services were complete, you would render your bill and they would have 30 days to pay it. Why is this case any different than the others?
Because this case is for breach of a contract. I'm confused as to which issue we're talking about, whether we're talking about statute of limitations or issue 3, whether there was a contract.
We're talking about establishing when the contract ended and when you were supposed to submit your bill. You're saying you could submit your bill 20 or 30 or 50 years later.
Hypothetically.
Because the contract didn't end. And I'm saying that your course of dealing seems to me to indicate that the contract ended when the services were provided, and that you had at that point 30 to 60 days after to submit your bill, not 20 or 30 years, and they had 30 days to pay after that. That's what I'm getting at.
A contract doesn't expire, using your terminology, Judge Sawaya, when services are completed. A contract expires when the payer pays the bill. Now, there is an issue here about a delay in the submission of the invoice. No question.
No, I'm getting, the issue that I'm talking about is the issue that Judge Palmer brought up in his question. You could submit a bill 20 or 50 years later, because at that point, the contract doesn't end until you submit. There's no breach of contract until you submit the bill and they refuse to pay. I'm saying that the course of dealing seems to indicate otherwise. That you had with these people, and that the course of dealing, if the contract is silent as to when the submission of the bill is supposed to be paid, the course of dealing would indicate 30 to 60 days after the services ended, and not 20 or 30 or 50 years later.
Well, on the law, I would agree 20 to 50. But that would be a case on those facts that would be different. This is a case on these facts. And let me say this about the delay. Whether the delay in submitting the invoice was within the course of dealings, was reasonable or unreasonable, is an issue of fact. And Mr. Watson testified to 7 reasons why he delayed this. Whether those issues were credible, whether they were reasonable or unreasonable, presents a jury question.
How long was the delay in this case?
The services were completed on January 2004 when the renewal contract was signed. The invoice was submitted after much wrangling on September of 2007.
3.5 years later.
3.5 years
Is
later.
it your position that it is always a question of fact as to whether or not the delay is reasonable?
Not always.
What determines whether it's a legal issue or a factual issue? You say it's a factual issue here. If you had brought it in 20 years and argued 40 reasons why I waited 20 years, it's your position that that would inherently be a fact issue that would go to a jury, that a judge could not, as a matter of law, say 20 years was unreasonable?
No, a trial judge could say that, but that's...
So if a trial judge could say 20 years was unreasonable, could a trial judge say that 3.5 years was unreasonable as a matter of law?
A trial judge could, but again, it depends on which issue we're talking about. Are we talking about statute of limitations, or are we talking about the existence of a contract? Because if we're talking about statute of limitations, it doesn't matter whether there was a delay. You cannot file a lawsuit in Florida for breach of contract until a breach has occurred.
But
now, if you're partly responsible for that breach being a long period of time, that's a different issue. But you can't file the suit until a breach is occurred. So there is no statute of limitations issue. I think the harder issue is here...
Well, the breach is the failure to pay, correct?
Correct.
Because each side had to send the invoice, right?
Each side had duties.
You would not necessarily have had to send an invoice, correct? If you had a contract here where there was a set amount of money, all right, let's say that you had a contract that said you will pay me $800,000 for these services, okay? You finished your services and you did nothing else. Would Florida Power have an obligation to pay you the money?
Well, yes, if there was...
And if they didn't pay you the money, could you bring a lawsuit without having submitted an invoice?
Yes, because... Yes.
Okay, so the invoice doesn't... You don't have to send the invoice to have the cause of action mature, correct?
In your example, however, Judge Palmer, that you've already agreed on a price. They've already said, I'm going to pay you $800,000. There was no agreement here as to the amount. So it wasn't a self-executing obligation for them to pay him X dollars when he finished his services. He would have to send them an invoice and say, this is what the value of what I did for you to obtain this $300 million contract is.
Under the contract would be to submit an invoice, correct?
In this case, yes, because the whole course of
dealings... Would it be a requirement that he submit an invoice within a reasonable period of time? Perhaps under the implied covenant of good faith in every contract? Or could he wait 20 years?
That issue, that argument has not been raised. It's not in your covenant of good faith. The only issue is whether there was a contract. And the issue that seems to be troubling this court is the 3.5 years in delay in asking for payment. What I'm saying to you is the record is undisputed. There are 7 reasons why he didn't. And if a jury wanted to reject that and say, you know, I don't believe you on these 7 reasons, so therefore I'm going to find there wasn't a contract, that's for a jury to decide.
And if a jury wanted to reject 40 reasons because somebody waited 25 years, your position would be that's for the jury to decide, right?
Yes. The only thing that's troubling this court is the time period between the end of the services and sending the invoice. The record, and we have put those facts in the briefs, the record shows why that delay happened. There is no requirement in the law that you must send an invoice within X period of time. The course of dealings argument, Judge Sawaya, goes to the implied contract issue, not whether an oral contract existed. The only thing that's important in whether an oral contract existed is, was there a meeting of the minds, we want you to do X, we want you to give us this contract, and we'll take care of you. In the context of what do I get out of this if I help you get the contract? We'll take care of you. That's what was said. Was that reasonable for Mr. Watson to believe they would pay him after they'd already told him they're paying a similar consultant $50,000 a month to get the Winter Park deal? So the issue really as to whether there was an oral contract here is a question of credibility. Mr. Raley, Progress Energy's witness, the vice president, was never asked, did you say this? And if you did say it, what did you mean?
Well, Mr. Hope, wasn't it the intention of the parties that this contract was going to be and could have been performed within 1 year? That was the time period that you had to negotiate the new franchise agreement with Progress Energy, correct?
The record is silent as to when the contract expired. That information was within the possession of Progress Energy. It is not in this record. All we know is that in the late spring of 2003, Progress Energy was getting nervous about this contract. We don't know when it was set to expire.
But Progress Energy approached your client to affect or help with the negotiation process as far as the city of Apopka went.
Correct.
And there was an understanding as to when that contract was going to expire, correct?
No, Your Honor. That is not in the record. And I made that very clear in my brief. They're the only ones that know that. The contract itself is not in the record. We don't know if it was for 20 or 30 years, and we don't know the date it was set to expire. We just know that they were getting seriously concerned about this as to losing this contract.
Your position is your client does not agree that the agreement for your client to help in the negotiations with Progress Energy was going to take 1 year. Is that correct?
No, Your Honor. I believe you're now going to the statute of frauds issue, if I'm understanding you correctly.
Well, I think the statute of frauds, the statute of limitations, we're all talking about the contract.
Okay.
And there being an agreement. That's what we've been focusing on this entire time, and whether or not the statute of limitations attaches to that. So I think they're all tied into the same thing. But your position is it's your client's understanding was not that the contract for this particular negotiation would take place or be performed within 1 year. Is that correct?
No, you're right. My client had no idea when the contract was going to expire. He was not told. It's not in this record. All we know is that they said in their brief that it could be done within 12 months, and the trial court found that it could be done within 12 months and was done within 12 months. So we don't have a statute of frauds issue at all. You don't even get to that issue because you have full performance, so statute of frauds doesn't apply.
He had to know his services were completed on January 7th, according to the final judgment, because that was the date that the city of Apopka approved its renewal franchise agreement with Progress Energy. So your statement that he didn't know when the contract was supposed to end it, I mean, simply is belied by what the trial court said in the final judgment, right?
No, Your Honor.
Well, it says January 7th, 2004 is the date. He's saying that's when the services ended. That's because that's the date that the city of Apopka approved its renewed franchise agreement with Progress Energy. So what services did he have to render after that?
None.
So he had to know at that point that his services had concluded.
And he did.
Well, then the only thing left to do at that point is when do you submit a bill?
Yes.
At that point, the ball was in your client's court. So then your client waited this protracted period of time to send a bill.
Yes.
Correct?
Yes, Your Honor.
So there was nothing that Progress Energy needed to do at that point. All eyes were focused on your client and what your client was going to do with regard to that agreement that had been reached between the two parties for the negotiations for the franchise agreement, correct?
Correct. That is correct. But the contract the statute doesn't start until the contract's breached. Whether the contract existed in this case is a disputed issue of fact. There are a lot of facts in this case from which a jury trial could find for Progress Energy and could find for Mr. Watson. The whole point here is this determination was not proper on summary judgment. It basically comes down to credibility determination. Is Mr. Watson telling the truth that he had a contract but waited a period of time to submit his invoice, or is he not telling the truth? That's not proper on summary judgment. A jury must determine that.
Thank you, counsel. Your time's expired.
May it please the Court. My name is Joseph Justice, and I am here along with Pierre Secord to represent Progress Energy in this appeal. And obviously, as the Court is aware, this is an appeal of a summary judgment that was entered in favor of Progress Energy on a statute of limitations ground. And this appeal, I'm going to focus on the statute of limitations issue because that is what the trial court decided. The appeal presents this Court with a fairly narrow question, and it is one that is a pure question of law, and that is, when did the statute of limitations begin to run in this case? This is not a case of first impression in the state of Florida. This same issue has been presented, at least in one other case, the Bernholz versus Steisel case, to the 3rd District Court of Appeals. And in that case, it was a similar, actually a very similar set of circumstances, with the exception that the services being rendered were legal services. But it was a service contract for the provision of continuous services over an indefinite period of time, and it was an agreement where there was no...
Well, your position is that if it's a service contract, then the time fixed is when the services end, and that's when the cause of action accrues.
Yes, Your Honor, and that is exactly what Steisel found. And does
the other side have some reasonable period of time to send an invoice, especially in a context where they say that you don't have a defined price for the contract?
Pursuant to the Steisel case, the breach would occur, or I shouldn't say the breach, the right to bring the cause of action begins the time that the services are completed. And that, by the way, Mr. Watson, although he is not a lawyer, that was his own understanding. So
they could have brought this cause of action without ever submitting an invoice.
They could have. They absolutely could have. Now,
they wouldn't be subject to a defense of, we didn't even know how much we owed you?
Well, I think there would be a defense of that, of course. There would be the defense that, and that goes back to what Judge Sawaya indicated early on in the first argument, which is simply that we don't have an agreement here on essential terms.
When you start deleting terms like how much is due, I mean, then you're getting to the question: was there an agreement in the beginning when those sorts of important material issues aren't even included in the agreement? I guess then the issue is: was there an agreement? And that would seem to indicate there was not from the beginning. But
and that is, Your Honor, exactly what we have argued here. But I think for the purposes of the statute of limitations issue, that is probably not something that the lower court would be able to look to in the statute of limitations issue context. What the lower court had to look at is, well, when does the right of action arise? And what the cases say, Bernholz versus Steisel, Bernholz versus Blake, a number of other cases say the statute of limitations begins when the right of action accrues. And the right of action accrues when a right to some recompense arises in the plaintiff and a consequent obligation arises in the defendant. And that happened when the services were completed, if there was in fact an agreement. Mr. Watson and his company was owed the money for those services on that day.
Well, but you would need to know what the amount is. I mean, for you to take the position that once the franchise agreement was signed, then the cause of action for breach of contract accrued. At that point, you didn't even know, there was no agreement as far as what was the hourly rate, how many hours the work had been completed. There was a corresponding arrangement between the appellant and Progress Energy for other work that did not include negotiation of this franchise agreement. So how can you say that the cause of action accrued right when the franchise agreement was signed when you don't even know what the amount that you would be litigating over as far as the breach of contract? There's no damages there yet. Wouldn't it be a reasonable time, and in this case, course of dealings would be 30, 60, or even 90 days out, would be a reasonable period of time to expect a bill and to expect payment?
Well, under the course of dealings, Your Honor, is correct, that the course of dealings was that they would send an invoice within 30 to 60 days, and it would be paid net 30. And if you were to assume that there should be some reasonable time period to send the invoice, this case is still not saved from the statute of limitations. That merely means instead of filing the claim 12 months too late, the appellant filed it 9 months too late. It is still barred by the statute of limitations because that reasonable time period would take us from January 7, 2004 out to February, March, somewhere around April 7, April 8, April 9 of 2004, not all the way to September 11, 2007. The delay here was a 45-month delay in sending the invoice. And I think the first question that was asked there really goes not so much to whether the statute of limitations began when the services were rendered, but rather, did we have a contract in the first place? And that's an argument that I'm not sure really can enter into the statute of limitations claim. I think when you come to the court on a summary judgment motion on each of the different issues, and there were 3 issues in the summary judgment motion, the court has to look at each issue and look to the facts in favor, in a light that is seen in most favor to the non-moving party, which in this case would have been HB and Company Services, Inc. And if you are going to look at the facts on the statute of limitations issue in the light most favorable to them, you have to assume for those purposes and those purposes only that there was some valid agreement. Now, the question is a good question because certainly the party that's being asked to pay, that party being Progress Energy, would be left scratching their heads as to how much I should submit. But nonetheless, whatever right he has to recover, whatever right he has to be paid, whatever that amount's going to be, it is due and owing on the date he completes services. That is what the Steisel case says. And the Steisel case is not a quantum meruit claim case. The Steisel case involved an appeal of 8 different counts, all of which had been thrown out on summary judgment. There were 2 counts that didn't go out on summary judgment. It was a 10-count complaint. But what is very important to point out is that while 7 of those 8 were quantum meruit claims, count 1 was actually a breach of a written contract claim. And the Steisel case applied this rule the rule that the statute of limitations begins when the services are completed to all of those claims, including the breach of contract claim. And it really, if you look at the reasoning of the Steisel case, it's the only reasonable way to view these types of cases where no one has agreed as to when payment is due. Because the panel is absolutely right. If you take the argument put forward by the appellant in this case to its logical conclusion, a corporation could wait to send an invoice for 10 years, 20 years, 30 years, 50 years. Corporations do not have life expectancies. They can live forever. They could wait a century if they wanted to. And actually, the other danger that you can see in a case like this, we see in this case. Mr. Watson didn't submit his invoice until the one person involved in these discussions, that is Mr. Raley, was no longer with Progress Energy. So he could wait until the only person who'd be able to talk to anybody about what we did or didn't talk to was gone, and then bring his claim, and there'd be no way to discern whether his claim is valid or not. And that is the reason why the Steisel court stated very clearly, such a rule as is being put forward by the appellant is unsatisfactorily contrary to the very purpose of a statute of limitations. It allows a party such as Mr. Watson and his company to, at their discretion, delay the start of the statute of limitations ad infinitum. There would never be a resolution to this case if he didn't want there to be. And it cannot be that way. So that is our position. The appellant has cited no cases that really run counter to this. All the cases he cited are easily distinguished. We've done that in the answer brief. The main ones that he hung his hat on were these payment-on-demand cases. The payment-on-demand cases, those by their nature are not due until there's demand made. More importantly, as those cases point out, there's a specific statute that deal with those types of cases. The second half of Section 95.031 states that in a loan-on-demand case, the statute of limitations does not begin to run until the demand is made. So those cases don't apply, and really none of the other cases do. I'm certainly willing to answer any other questions on the limitations issue. Hearing none, I'll just briefly touch on the other points, although I don't think obviously our position is this is a statute of limitations case, as the initial brief raised, but also the motion for summary judgment. The defense to that defense raised by the appellant does raise some issues with the statute of frauds, at least some interesting sort of intellectual issue, which is this.
Before I forget, your motion for attorney's fees, the fees were based solely on the offer of judgment, right? The request for fees, you filed a request for fees in this court?
They were.
Is that solely based, I have to go back and refresh my memory on the motion, is that based solely on offer of judgment statute?
Yes, yes, sir. And briefly on the fraud, statute of frauds issue. If the appellant is correct in their argument that a cause of action does not accrue until the invoice is sent and is then rejected, then this is not a case where the only thing left to be performed, or the only thing left to be done as of January 7, 2004, is payment by one party. This is a case where neither party has performed their obligations under the contract until September 11, 2007. So that raises a question, does this then bring the case back into the statute of frauds? There's no term limit or time limit in this contract to determine, or this alleged agreement, to determine when the services would be completed. Therefore, you can't say with certainty, okay, it cannot be done within 12 months. But Mr. Watson admitted at his deposition he didn't know if it would be done in 12 months. What the cases on the statute of frauds state is that, the language of the statute of frauds is any contract that is not to be performed within 12 months cannot be enforced unless it is in writing. It's not that it can't be performed, it's not to be performed. And as a result, the cases that speak to the statute of frauds, and one from this court, the Apsoft versus Webclay case, state that in those scenarios, if the contract can be performed in 12 months, then you need to look to the intent of the parties. And the only point I want to make on that is, while there may be some dispute over what exactly all the reasons were for Mr. Watson's delay in submitting his invoice, he was very clear at his deposition that one of his reasons was to delay the tax consequences of the income that would come from this alleged agreement from the year 2004 through 2005, 2006, and into 2007. Whatever other reasons there may have been, that one reason shows that that party, HB and Company Services, Inc., did not intend to complete that part of this contract within 12 months. And therefore, if the argument by appellant is correct, which we don't agree with, but nonetheless, if the court is swayed by this argument that the statute of limitations doesn't begin to run because the action hasn't accrued until an invoice is sent, then this case is within the statute of frauds, and it should, and the trial court's conclusion would be correct for that reason as well. And then the last issue that was raised, it's a tipsy coachman issue. This wasn't really addressed by the court. I think the trial court's ruling was all of this contract issue sounds very interesting. Too bad you took too long to bring the case. It would be interesting to talk about those things. So the trial court didn't address this. But it was our position that there was no valid contract here. And it does appear from the initial and reply briefs that, at least as it relates to an express agreement, the appellant agrees. Because he never argues that there was an agreement between the two parties. Doesn't argue that Mr. Raley said, I will pay you X if you do Y. And he doesn't even argue that Mr. Watson recalls being told that. What he wants to do is imply terms into a contract that didn't otherwise exist through a stated statement. And this is not the proper case for that. And the reason is, in order to imply...
But the trial court didn't rule on it. I mean, do we need to really spend a lot of time discussing it? Did you have anything else you wanted to say?
That's everything I wanted to say on limitations and frauds. I only brought it up because Your Honor had questions. If there are no other questions, I'll complete my time.
All right, thank you.
Thank you, counsel. The court will take its